we thought that, and the residence in which the rounds were fired in, and these two brave folks went, K-9 Tanya and Deputy Brown, went to apprehend a suspect. It caught on fire. So we weren't sure at the time if Tanya was killed by the fire or by the shots. So it was very important in preparing the case that we determine that. Only because of the courtesy of the GBI, they did an autopsy on Tanya. And the bill has it that it has to be performed now. It's a law enforcement animal, which could be a dog or a horse or whatever. And in putting this bill together, you can imagine, you probably have had some calls or emails about, I'm putting the life of a canine before the life of a human being. I'm putting the life of a canine before the life of an unborn child. And that's just completely ridiculous. There's some crazy people out there. This is just helping prepare the case for the next incident that may happen like this. We have come up, this establishes new crimes and punishments for killing or harming animals that are in the law enforcement community with a certain fourth degree, which is harming the animal, third degree, which is using a dangerous weapon to harm an animal, and second degree would be harming the animal so the animal cannot perform its duties anymore, and then the first degree would be killing the animal. And the fines are equivalent to that. In fact, it goes less for the fourth degree, then it climbs higher, of course, for the first degree of the animal being destroyed. And then, of course, restitution may be. And I don't know if you know about the training of these animals, but first off, the dog cost about $10,000. And then training the animal costs anywhere from $10,000 to $20,000, and then training an officer is another several tens of thousands. So it's a very expensive proposition. Be glad to answer any questions.
It's a tremendous resource that I don't think people may not be aware of, and it's a long-term commitment too.
Yes.
Because you're dealing with an animal at a very specific age during a specific time period with specific training, and then the personal cost for the training itself and
for the taxpayers,
supplies and so forth.
Well said, Mr. Chairman.
So, just to make sure it's clear, we're operating on LC 410406S. Is that correct? The substitute?
Yes.
That came out of Senate Public Safety?
Yeah, that's right. And then
Okay.
we gave you some more of the language. Legal counsel with Lieutenant Governor thought maybe it needed to all go into the new animal section instead of any in the human section. That's what you have secondarily. You see
Okay,
that?
is that the amendment
Yeah.
that we're looking at?
And
Counsel, do you have that? Do you have the amendment? Okay.
Yes.
Yeah. Is it clear?
And that's up to your discretion. You know.
Could you repeat what you said about the amendment and what the intent is there?
Yeah, they thought that some of it was put in the human section, and it all needed to be in the new section.
You thought in this new code section, you've got some way of using a dog, which might be considered a simple battery, and then you've got the one punishment under simple battery, and then you have the animal punishment. By striking it in this amendment, you're now keeping all the animal punishments.
Okay.
That's correct. That's
Okay.
correct. Thank you, Counsel.
Okay. Questions for the author or for the deputy vice chair?
Thank you, Mr. Chairman. In the case of a death of the law enforcement animal, I know that Mr. Chair, you've talked about the high cost of actually, and I noticed that there is a restitution provision in here.
That's right.
But I'm wondering if the penalty in line 84 of $20,000 max is too low.
Well, it's up to that. And I think, Chairman, I gave you some stats from other states I don't have with me. It ranges from lower to even $250,000 on the left coast. So whatever the wisdom of this committee would be fine with me, but just want to make sure we can pass it.
Okay, thank you.
Do you have any idea along those lines, given the resource conversation that we just had? I mean, I don't pretend to know what the round figure is from the beginning, the cost to the officer,
Here's your chance.
to the training, supplies, all the resources that go involved, some of which we probably contemplate, some of which we just don't because we don't have the background. I know it's dangerous to ballpark figures, but to the vice chairman's point about it not being enough to compensate the community, because that's what it is.
Yeah, your
It's
taxpayer
compensating the
dollars.
community for the loss of that resource, and the animal's a resource. So, do you have an opinion about that?
Yes, sir, I do. like Senator Mullis said, the K9 itself, you know, on our end is around 10,000. Out on the West Coast, you're looking at 25,000. And so by the time you buy equipment, tracking harnesses, muzzles, leashes, multiple links that you have to have, dog food, vet bills, you're probably looking in on an average yearly about 35,000 on the average, and that comes. I get that figure from K9 organizations within this state. I contacted multiple trainers, and that is about the ballpark figure on a yearly average is what they're estimating upkeep cost of continuing training for the dog and the officer, and equipment and veterinary bills and food.
So arguably the 20,000 really wouldn't make a dent in the loss that on the resources. So maybe we'll take a look at that in the context of an amendment at the appropriate time.
And I mean, there's what they have mixed law in Pittsburgh, Pennsylvania, and that is another K9 that was killed back in 2014, and they have recently upped their penalties in their law, which is up to $10,000 for killing a K9 and a $250,000 fine. And then you have Rocco's law from out west, where it's up to 10 years in prison for killing a K9 and $25,000. So there's two different laws that were just passed in 2014 from around our United States here that, you know, maybe it can give y'all something to base on.
Thank you. I mean, in the context of if the committee in its wisdom was going to go ahead and make some changes, if you look at the third degree, then you have, that's a serious injury. And so if there's a serious physical injury, that will render the animal survives, assumedly, but probably renders the resource non-existent to the department at that point. Is that fairly so?
Yes, sir.
It seems to me that's as much of a loss as if, from a community resource standpoint, that's as much of a loss as if the animal didn't exist anymore. So maybe the law should reflect that. And that's just by way of friendly amendment. Mr. Grabbley. Okay. Mr. Setzler.
Mr. Chairman, forgive me for just getting there. I want to make sure there's understanding if there's any sub-language being contemplated.
Can you press the button that's on the back of your microphone, on the back of the microphone?
Thank you.
Okay.
The distinctions, the elements that would create a first degree, how is that distinct from a second degree under this?
Yeah, the first degree would be the dog would be dead. The second degree would be harmed, so it couldn't perform its duties any further, any longer, basically.
You know, I'm persuaded by the cost discussion here, and as I look at this, it's persuasive to me as you look through from a civil perspective, or even from a criminal perspective, criminal penalties perspective, being able to recover an amount of money that allows the department to go through the full training and all the individual officer time and that whole team concept that's got to happen. I'm persuaded on the dollar side. I really struggle on the felony side. Why felony specifically when we're talking about an animal?
Well, sir, under current law right now, 1611-107, killing a police dog is already a felony in this state with a sentence of 1 to 5 years currently. So right now, as it stands, it's already a felony in this state. And we just, under this new law, it changes it from 18 months to 5 years, which I would really like to see it 5 to 10 personally.
I say it may be, I may be the skunk at the party here. I mean, I'd be fine to take the penalty, from 20,000 and take it to whatever it needs to be. I have no issue with that. I wrestle with felony treatment for killing of an animal. You look at the protections we provide for human life, and the protections where we fall short of providing and protecting human life. And I know this is not the gentleman's, I don't want to get the gentleman tied up in this, because it's certainly not the chairman's intent. I have serious misgivings with felony treatment for taking the life of an animal. I think it could be ignored and sort of cast off as being ideological in nature, but I think it's an important principle.
Let me interject that I think last year we had an animal cruelty bill that heightened the punishment. It became a felony. It essentially heightened the punishment for animal cruelty for factual circumstances that did not involve the killing of the animal. It could have, and I can't quote it exactly right now, although I probably could have last year. But so I mean, there is precedent for felony treatment for treatment of an animal that is less than killing the animal.
I hear that, and forgive me if I was in the committee when that moved. I just, or if my objection wasn't strong enough in that respect. It doesn't speak to the essence of this bill, because I do think this bill, a lot of it that I'm so friendly to is the idea of criminal penalties. I just have an issue when there are, I'm going to say it, when we don't protect human life in the womb, and you've got children that are 7 months gestational age, that they have zero protection under this state's law. It has nothing to do with the gentleman's intent. We provide no protections there, and we're providing felony treatment 1 to 5 years for animals that are shot. I think we absolutely ought to have a crime for it, and I think there ought to be financial recovery. But I think it needs to be stated. It has nothing to do with the gentleman. This is not directly the author of the bill. I just want to say for the committee, and as a legislature, I think it's a bad policy statement to do that, and to not protect human life here, and to make these kinds of criminal penalties on the animal side. Just want to state that, Mr. Chairman.
Ms. Ballinger.
Deputy, can you just kind of go through kind of what a canine does and how they, because don't they often kind of stand in for officers and save the lives of officers by kind of taking down, kind of people that are up to no good? So don't they kind of stand in lieu a lot of times of law enforcement officers?
Yes, ma'am. If it wasn't for Tanya, Walker County Sheriff's Office I would guarantee you bury 3 officers that day.
And you being one of them.
Me being one of them. I mean, I was shot and injured from the same blast as my K9 got killed from. The unfortunate part is we don't have the opportunity of, I guess, silence when we enter with these K9s. Standard says we have to give 3 K9 warnings, so they know it's coming. We have to give loud verbal warnings. And if it's in a large structure, we have to do it all the way around. So it's like we're just waiting to be sniped, per se. And that's what happened in this case. I mean, he was right there waiting on us. And as soon as that door come open and she entered, it was all over.
But as a general rule, though, law enforcement uses canines in place of officers to save officer lives. Isn't that correct? And a lot of times they kind of, like I said, they stand in for law enforcement in that capacity. Correct?
Yes, ma'am. What we do is like in a situation where I'm just going to give a suicide subject barricade in a residence. Instead of, a lot of times they want to do suicide by cop, and instead of us going in there and getting a gun battle, we summons our canines to go in and only apprehend that subject, to bring them to us, or the subject surrender, and then we go get that particular person.
Okay.
And so yes, it is very crucial. And in my opinion, I think it saves a lot of human lives on the law enforcement side by using these canines.
Okay. Thank you.
Yes, ma'am.
I see no further questions. Thank you, Senator Mullis, and Deputy, and thank you for your service.
Yes,
It's
sir. Thank you.
outstanding, and the circumstances that day I know were hard enough, and then to relive that we know is no treat. So thank you for withstanding that.
Yes, sir. Thank you.
I see no one else has signed up to speak, so we'll take it back into the committee. Mr. Porter.
There are actually 2, and I mentioned this to the chair. On line 6 of the bill that has passed on session, it uses the phrase that says a police animal
Mm-hmm.
the course of its duty.
Yep.
Murder is a term of art.
Yep.
It refers to the killing of a human being. And that language, that the suggestion that the association should be changed to intentionally kill.
Is that reflected in in the bill in chief? I mean, that's in the that's in the caption. So is it reflected in the bill in chief?
An autopsy for an animal is the first out the bill for a mandated autopsy. And we worked with Senator Mullis on this bill, and we supported it, but I noticed those two things. It refers to murder in the caption of the bill in line 6.
Right.
And it refers to autopsy as being mandated by the DEI, and the actual term would be necropsy.
Do you have a line location?
Mr. Chairman, I'd like to thank the prosecuting attorney's office for helping us construct this bill, especially the latter part.
Thank you. Counsel, where are you at?
Yeah, the autopsy's on line 5, and I'm not understanding what he's saying the right word is.
Necropsy? What I see, Ms. Ballinger pointed out, beginning on line 101, the Division of Forensic Sciences of the GBI shall perform forensic pathology services. Okay, so that'll stand as correct. So really, we're just talking about the word in the caption. Okay, okay, we'll take that as an amendment. Well, actually, do we really need to do that for purposes of the caption? All right, yeah, okay, okay. Mr. Pack, do you have something else?
The item that Mr. Chair, you and I talked about, just the question on line 56, we have knowingly and intentionally for the intent element, and every other section except for if you look at line 63, so it's just knowingly. Is that shouldn't it be knowingly and intentionally? And I guess then becomes kind of a wording issue. He or she knowingly and intentionally and with a deadly weapon causes. I know that's a term of art. Because when you add the when used offensively against such law enforcement animal, it becomes, I guess that's consistent with the other statutes that we have.
Counsel, you see where we're at?
Yes, sir.
Okay, do you,
What line is that?
63.
It's right at the top of the page.
Is that just a cleanup?
I think
It's mirrored on
Representative Pack makes a good point that
Mhm.
to add intentionally and after the and before the
Okay,
would make the bill consistent,
okay.
the language consistent.
On the motion, I'm going to go ahead and ask the Vice Chair to make that amendment.
And one other comment about the difference between restitution and kind of fine. The reason I noted the fine is just, I guess, in terms of the if a law enforcement animal is injured and you have continuing kind of costs, it's kind of hard to. I know we're talking about the amount to train, but that could be completely different from kind of maintaining a quality care for the animal for the rest of its life. I'm struggling with what would be the best way to do that. Is it just
And the fine don't normally go to the animal or the department. It would go to
right?
general budget of the county. Is that right?
Right, but I mean, but they're going to go ahead and petition the county commissioner for the replacement of the resource, I would think.
Under the language of restitution, you can get every, and this was your bill, Mr. Chairman, many years ago.
It's all coming back now.
Restitution
Thought I had effectively repressed the whole thing.
Yeah.
any kind of damages you could get in a civil case.
Right.
And
Okay.
in a wrongful death. So I think that like the ongoing care would be an argument that the prosecutor would be making at the time of sentencing in terms of imposing restitution in a manner of proof. And that reference to 1714 is on lines 89 and 90.
I'm good with whatever you want to do.
Okay, we'll see where it leads. All right, with that, what is the pleasure of the committee? Ms. Ballinger. We'll go ahead and do that after the motion then.
I'd like to make a motion to pass Senate Bill 72, LC 410406S.
Ms. Ballinger moves due pass of SB 72, LC 410406S. Is there a second?
Second.
Second by Mr. Strickland. Are there any amendments? Mr. Pack.
Thank you, Mr. Chair. On line 63, after the word knowingly, insert and intentionally.
Mr. Pack offers on line 63, insert the word after knowingly and intentionally, as per the conversation a minute ago. Is there any objection to the amendment? Any objection to the amendment? Hearing none, the amendment is adopted. Any further amendments?
I think we should raise this.
Mr. Pack.
On line 84 for the $20,000 fine, I just think that it's a little bit low comparing if the animal's unfortunately deceased. I think that $20,000 might not be enough deterrent for that type of conduct. To the extent I propose changing 20 to maybe 50,000 as a fine.
Mr. Pack offers an amendment to strike on line 20, line 84, striking 20,000 and inserting $50,000 in its place. Is there any objection to the amendment?
Can I ask a question?
Please. Sure.
So the purpose of changing the fine.
Let me ask you to pull your mic if you could.
So the purpose, can you hear me, of changing the fine is you're trying to have it as sort of punitive damages to deter, because I'm reading on line 90 through 95, so they have a mechanism already set up to sort of pay restitution, and it talks about the value of the animal and all costs associated with training. So are you trying to have a punitive measure?
Right, as more of a deterrent. It's not to compensate, but I feel like the deputy kind of, when he did the survey of the various laws, it ranged from a low of 20,000 to 250. I'd rather be something a little higher than 20,000 if that's going to provide even an incremental deterrence to attacking a law enforcement animal.
Mr. Chair, I had a follow-up question if you.
Sure.
So if you're going to change the line 84 from 20 to 50,000, is it your intention to change the rest of them accordingly, or just that one?
We were just having that conversation.
I'm sorry.
Would the lady like to offer an amendment?
I don't have a number to pick out of. I just think we do obviously need to change the rest of them, so I don't have a number in mind.
I'd
What-
like.
Go ahead. I'm sorry, Mr. Chair.
No, you.
Sure.
Mr. Sessler.
I'd like to offer an amendment to change 15,000 on line 77 to 25,000.
Mr. Setzler offers an amendment to strike $15,000 on line 77 and to substitute 25,000.
Because you've got contemplating a serious injury here.
Right. Is there any objection to that amendment on line 77? Hearing none, it's adopted. Any further amendments?
Mr. Chairman, I'm sorry, actually line 70 is an error I'm seeing. That $10,000, the maximum punishment that's allowed for high and aggravated misdemeanor is 5,000.
Okay. So I'll go ahead and offer a corrective amendment on line 70 to strike 10,000 and put in 5,000 as per council's advice. Is there objection to that amendment? Hearing none, it's adopted.
Okay.
Mr. Chairman, did you, my sense is you want us to go ahead and go forward on AM 410085 as per the discussion before.
Sure.
Let me offer AM 410085 as per the discussion before. Is there any objection to the amendment?
Happy to help my House colleagues.
Here, thank you so much. This is a good bill, and I'm really glad that you brought it, regardless of the circumstances, as difficult as they are. I'm sorry, is there objection to AM 410085 as an amendment? Hearing none, it's adopted. Are there any further amendments? Ms. Kendrick, is your light flashing?
Oh, I don't know why.
Okay. Are there any further amendments? The chair is going to offer, and Mr. Chairman, this is as per the conversation earlier in the meeting that the committee had this morning, and thank you again for your willingness to allow SB 72 to be to carry a couple of pieces of worthy legislation that just couldn't make it. Yep, thank you. I'm going to offer HB 578 by Chairman Weldon that passed out of this committee earlier this morning. I'm going to offer as an amendment that substitute, which is LC 296592S. Is that the correct substitute? And that is the version that struck the word annoying. So the chair is going to offer that amendment as per the conversation earlier as an amendment, the substitute that we passed out earlier to HB 578, LC 296592S. Is there objection to that amendment? Hearing none, the amendment is adopted. The chair is also going to offer HB 534 that was passed out earlier as an amendment here to SB 72. It's LC 296503. Again, thank you to Chairman Mullis for allowing Representative Chandler to catch a ride on 72. Is there any objection to adding HB 534 as an amendment now to SB 72? Hearing none, that amendment is adopted. There's an underlying motion of due pass. We'll make that by substitute with all of the amendments that we've discussed. Are there any further amendments? Is there any further discussion? Seeing none, all in favor of the gentlelady's underlying motion signify by saying aye. Aye. Opposed? The ayes have it, and the motion's adopted. Thank you, Mr. Chairman.
Thank you so much. And, you know, I have a little committee over in the Senate. If I can be of service to anybody here, appreciate it.
Thank you very much. Thank you, Mr. Chairman. Thank you, Deputy, for your service.
Representative Weldon will be taking care of this.
Oh, no, thank you.
Well,
It's already passed.
that changes the landscape.
Thank you, Mr. Chairman. Thank you, ladies and gentlemen.
Thank you. Senator Bethel. Senator Bethel has SB 94. Senator, welcome.
Thank you, Mr. Chairman, and thank you, members of the committee. I bring before you Senate Bill 94. I'm working from LC 296438S. That is the version that passed the Senate. My anticipated House sponsor will be Representative Alex Atwood. Mr. Chairman, members of the committee, Senate Bill 94 really just is an attempt to codify best practices when it comes to eyewitness identification procedures. The language of the statute really follows what is being taught now at GIPSTIC and across Georgia with our law enforcement agencies, but it puts into code these practices, and I would direct the committee's attention really to the operative language, which is on page 2 in lines 30 through 58. The key piece of this is that it captures what people who deal in this world as the core four. It's four sort of basic principles. The first is that in a live lineup setting, the person conducting the lineup does not know who the anticipated suspect would be, so that they're not even unconsciously or sort of unwittingly prompting a witness as to who they should choose or might want to choose. The second is that individuals in the lineup have a general resemblance to the traits that the witness identified, which obviously is common sense, including a statement for the witness that the person or the suspect may or may not be present in the lineup that's presented to them. And again, it stands to reason, but sometimes people have the impulse to choose and they think they're supposed to find the person, and reminding them that they may not be part of the lineup is important. And then recording a confidence statement from the witness at the time that they make the identification, so that if somebody says, I'm absolutely certain, we've got a record of that. If they say, that really looks like the person, but I'm not sure, we've got a record of that. Again, those are the best practices pieces. One of the questions that came up from Representative Reeves deals with show-ups. Again, most of you who are familiar with the process, you've got live lineups, photo lineups, and then show-ups. The only real operative language dealing with a show up is the confidence statement, the capturing of the confidence statement. So most of the language deals with live lineups and photo lineups, and for a photo lineup, to account for the issue of not knowing, it just calls for the shuffling of those photographs, which again is best practice and standard procedure. I would certainly welcome and stand for any questions that the committee or the chair has. I also know that there is some interest from the Prosecuting Attorney's Council to add language. I am amenable to that and would defer to the committee's wisdom and judgment on that issue.
Thank you, Senator. Questions for the author? Vice Chair.
Quick question. Line 60 to 62, and I'm just not familiar with this process. Maybe Mr. Porter could help me on this. If it says the court may consider the failure for the exclusion of identification evidence, does that include the in-court identification or just the lineup, kind of testimony related to previous lineup?
The actual an in-court identification can consist of two hearings. One is the suggestiveness of the pretrial identification procedure can influence the admissibility of the in-court identification if it is so prejudicial that the person can't identify the person in court. But it also can be an independent inquiry where the court could suppress only the prior out-of-court identification. What we tried to do in working with the experts and with Senator Bethel was to make sure that it was a factor if the police department failed to follow the procedure, but it was not dispositive and automatically.
The question would be, what standards would the court apply? Like, where is that line? I think this is enough to exclude. And
I would say that from my standpoint, I think that those that participated in the process of creating what I consider to be a sort of consensus piece of legislation, we would let that fall in the discretion of the court. And if we determine that there's a problem, if any side has issue, then we may come back. I think if you over-legislate the process, you create sort of some hyper-technical test that may or may not be practical when it plays out in the courtroom. From my standpoint, I think, if I'm looking at it as a judge, if I find that failure to follow these basic principles is so extreme that justice won't be served by allowing this evidence, then you may use your discretion to suppress or exclude. But if you find that somebody said, the policy is this, and you've got this written policy, and it wasn't in such a way that was likely to disrupt the identification, then you'll allow the witness to be questioned about that, discrepancy, but you certainly allow that to go to a jury.
the only just practical concern that I have is it doesn't require the court to make a specific finding as to why it's unreliable. So it seems to me it's a virtually unreviewable decision, if at all.
Well,
I just don't know how that works in court.
I mean, obviously, any decision, thank you, Representative, is reviewable for abuse of discretion.
Right.
I mean, at the appellate level, any discretionary decision. I mean, I would think it would be the way it's written, I would interpret that as a purely discretionary decision. But I think if they had no findings, then I would say that would be an abuse of discretion. In other words, if they just simply said it's suppressed because you didn't follow your policy, I would imagine that an appellate panel would say, well, that's not what it says. It says you have to have more than just a mandate.
One last question. I'm sorry. So is a standard for excluding generally just unreliability of the identification?
In general, it's that the pretrial, the finding that the pretrial identification procedure was so tainted that it was so suggestive that it tainted the in-court identification. That's the finding.
All right. Thank you.
For some reason, it was so suggestive that it influenced the in-court identification.
Any further questions for the author, members of the committee? Seeing none. Senator, thank you.
Thank you, Mr. Chairman, members of the committee.
Mr. Porter, do you want to come forward and sort of give us the how we got here?
Yes.
Thank you.
Would you like for me to stay, Mr. Chairman? Or?
It's up to you, Senator. I mean, I know you.
and Representative Atwood.
Thank you, Mr. Chairman. This is a bill that is a number of years in the making. We have been meeting with members of the Georgia Association of Criminal Defense Lawyers, as well as experts from the Innocence Project and experts in the field of eyewitness identification. And I won't bore the committee with all those meetings, but it had to do with trying to establish policies that would assure the reliability of eyewitness identifications and the pretrial procedures, so that the pretrial procedures didn't influence the in-court identification, that they were accurate all the way through. And we all agreed basically on what the best practices were in terms of how the lineup should be administered, who should administer it, blind administration, shuffling, and sequential photographs. And so at the end, we came to a bill this year that we believe sets the standards for law enforcement. If they're going to choose to use these pretrial identification procedures, then the statute requires that they have the policies, and that those policies are not going to be a gotcha. They're not going to be that if you fail in some minor way, it's something that the court can factor in, but will not control suppression. And so I think it's sort of from both sides. It's a win that we've been working on several years. And I'll be happy to answer any questions.
Questions from Mr. Porter on SB 94. Ms. Kendrick.
Could you explain how our lineups and the different identifications are being done right now?
Sure. You basically have three types of pretrial identification procedures. You have a show-up. Show-up is a one-person. The police bring the person either back to the scene or bring the witness to where they've apprehended the defendant, and they say, is that him? These are the most suggestive and the most frowned upon by the courts, and there are certain rules that are required that we have to do that. And this bill requires a confidence statement by that witness that says, I'm confident that that is the person, or I'm pretty sure, I'm partially sure. But the more common is what's called a photographic lineup. Generally, photographic lineups are a folder that has 6 to 10 photographs of individuals that resemble the description of the eyewitness. They are shown to the witnesses, and that's where we get into the best practices. Traditionally, they've been put in a folder and shown as an array. The recommendations and the requirement of the bill is that they be shown in sequence and shuffled like a deck of cards and shown in sequence rather than all together at once, and that the test be administered by someone who doesn't know about the case, so they can't subtly influence the witness by nodding or winking or anything else to try and pick out the right person.
Oh, I guess let me rephrase my question. I meant to ask, if we're requiring written policies now, is that to suggest that right now, none of those
some departments that are certified, that are certified by either a national certification organization, have written policies, and some departments don't.
Vice Chair.
This is a question for Ms. Travis. In line 60 and 61, is it just me, or does that read a little bit weird all the way up to before the word provided? I feel like there's some words missing, maybe. The court may consider this failure in the context of maybe determining.
I think probably that is a typo. What we meant to say was that the court can consider the failure to follow the policy as a factor in its decision. But
is it an identification hearing, or
you would file the defense attorney would file a motion to suppress the in-court identification, and the basis of that would be the pretrial identification procedure was so suggestive that it influenced it.
Maybe
that's how procedurally you get to.
Maybe if it's.
Do you want to take a look at
to a challenge to an identification or something like that, right?
respect to any challenge
Any
to
challenge to an
identification,
identification, provided however,
that
right.
such failure shall not mandate the exclusion of. I think if you added after the word "to" in 61
Challenge.
to any challenge to an investigation,
Identification.
identification.
Okay.
I'm sorry.
Yeah.
That would correct the
All
language.
right. Yeah, that makes sense.
I see no further questions. Thank you, Mr.
Okay,
Porter.
thank you.
Let me call on Sandra Michaels for the Georgia Association of Criminal Defense Lawyers.
Thank you, Mr. Chairman. I'm here with Amy Maxwell from the Innocence Project. We were just here if anyone had questions. Thank you.
Okay, on that last point, on the last tweak on line 60,
That's fine.
okay,
Thank you.
no objection there?
No, sir.
All right. Ms. Maxwell, did you have anything? Or? No? Okay. I see no one else signed up to speak on SB 94. What is the pleasure of the committee? Ms. Ballinger.
Thank you, Mr. Chairman. I'd like to make a motion to pass Senate Bill 94, LC 296438S.
Ms. Ballinger moves do pass SB 94, LC 296438S. Is there a second? Second by Ms. Kendrick. Are there any amendments? Mr. Pack.
Thank you, Mr. Chair. On line 61, after the words respect to, I would like to insert any challenge to. Does that make sense?
Mr. Pack offers an amendment on line 61 after the words respect to insert the words any challenge to, so it would read with respect to any challenge to an identification.
Yes.
Please.
Can you obtain the same objective and just take out with respect to, just make it any challenge to, or does it make it more weird? I don't care either way. I'm just asking. Oh, you, okay, that's fine. That's fine, just asking.
Are there any further amendments? Chair's going to offer any further amendments from members of the committee? Chair's going to offer an amendment. It's HB 430 LC 296551 ERS that this committee passed this morning as an amendment to SB 94, and that comes with the agreement of the author. Is there any objection to the amending of HB 430 to SB 94? Mr. Setzler.
And forgive me for taking care of some constituents. I missed the hearing this morning. I was going to offer an amendment to the amendment that would be simply a tweak to 430 as it passed this morning. And if it pleases the chair, I'd like to talk about an amendment that was brought to me by based on some discussion in the Senate. I think they felt like it was an important part of the discussion I wanted to share with our committee, if I could. Sure. I'm online. If I could direct members to page 22 of the LC version, lines 739. A 430, yes. Thanks. On the 6551 ERS. Here it's talking about a law enforcement official in the performance of their official duties. What this allows to do, for example, if a law enforcement official comes to someone's door, for example, and says, hey, can I come in and take a look, can I walk through your house? Can I search your car? If the person says, yes, you can, then they're operating pursuant to consent. What sometimes folks, or what under the 737 through 739, what wouldn't necessarily be clear to them, though, is giving the officer consent to walk through their home or their property to search. It's not clear that they're giving consent to be filmed and be videotaped. And I think as a policy question, I would ask the committee to consider that there be if consent's being granted for a law enforcement official to observe, that there be knowledge of the person consenting, that they're not just consenting to an officer walking through, but they're consenting to an officer actually videotaping as they walk through. I do think there's a distinction between an officer walking through my property and videotaping my property as they go.
I think there may be a distinction in that the recording, and this goes to the body cam issue, right? That's what we're talking about
Yes.
here. So it is confined, as I read it, to the activities of the persons, as opposed to taking the grand tour
Sure.
of wherever. If
Um,
that
And
distinction matters.
And Mr. Chairman, I was going to offer an amendment that was distinct to the person. I'll read it. I've got copies I can share with committee members. I would simply would propose an amendment that would add to the end of, not change the end of the existing language, and add to the end of line 739, provided that if individuals other than law enforcement officer or his agent are being recorded, at least one of such individuals shall have verbally consented to such recording, or there's reasonable suspicion that a crime's been committed. So it wouldn't get involved if there's reasonable suspicion, and they approach somebody based on reasonable suspicion, they can let the body cam run and there's no issue. But if there's no reasonable suspicion and they're walking up to a person, really in any context, and having a conversation with a cop, that if they're taking the cop somewhere, or they're taking them to a private place to show them something, or to kind of advance the police officer's interest, where there is no that there's no reasonable suspicion, that the person understand that they're being videotaped. I think there's a distinction between talking to a police officer and taking a police officer somewhere and taking an officer somewhere to videotape things. I do think there's a distinction.
Let me ask, what is the harm or the potential harm that the amendment seeks to address?
That if I think I'm having a conversation with a police officer, that's one thing. If I realize I'm being videotaped, if I'm not in a circumstance where I've been approached by a police officer where he's got reasonable suspicion, and I'm really, in essence, I have to have a conversation with him. I say, hey, I'm glad to talk to you. I think there's a sense in which people need to know that conversation is being videotaped. We're giving them the authority to do that. But I think there needs to be an element of consent for people who have that interaction. They need to know that it's not just a conversation, but it's being a videotaped conversation.
On the surface, I see the point that you're making, but then I think to myself, well, if the person knows that they're being videotaped, well, now I know I'm being videotaped, I better tell the truth. As opposed to perhaps they're not aware, maybe that wouldn't occur. Lying to law enforcement's a felony either way. So, I mean, I
certainly hope that the case is that they recognize they're being recorded and their behavior gets better. I've heard that from law enforcement, that agencies that put cameras on all their police officers, they see the ladies and gentlemen of their community be ladies and gentlemen around the cops because they're being videotaped. But I think to the extent there is a different behavior set among people when they're being videotaped, just proves the point. There is a difference when you're being videotaped. Folks recognize that.
I'm going to recognize the vice chair to make a point, and then I want to hear from law enforcement if they have anything to add on the amendment. Vice Chair.
I think this was discussed in some subcommittee. One of the things, I think, putting this language in 737 to 739, it provides a law enforcement exception to the illegal recording, and I'm concerned that Mr. Chair's amendment to that would kind of gut the whole purpose of having this language in there, because if they get consent, I mean, you don't need this provision. And I think that's what we're trying to do. The thing is, law enforcement interaction with normal, ordinary citizens doesn't have to be with reasonable suspicion. I mean, it happens all the time. You're walking down the street and the police officer. My understanding, and Mr. Porter, correct me if I'm wrong on this, this just creates the federal statute has a law enforcement exception, period. So you can't prosecute a law enforcement officer for recording if it's for law enforcement purposes. And I thought this was just codifying that exception under state law. I do think that adding a consent element would actually put us back into the harm that we were trying to do.
And I appreciate the question, but the consent element only exists on a subset. I agree with the gentleman. I think if a police officer walks up and is having a conversation pursuant to reasonable suspicion, I believe we do need to, this underlying language does need to give them the ability to videotape what's happening without the person necessarily knowing about it. So I think that's really the point I'm making, is if the cop's having a conversation, they don't need consent if they're having a necessary conversation pursuant to reasonable suspicion. The only distinction I'm making, or would make with the amendment, is that if there is no reasonable suspicion, the person doesn't have to talk to the police officer. They're just doing it sort of out of their own, kind of the goodness of their own heart, their own general cooperation. They're not cooperating. They don't know what they're cooperating with. They think they're cooperating with a conversation. They don't recognize they're being videotaped. And there's a material difference between being videotaped and having a conversation. Because I do not want to get in the way with what this is trying to do. What this is trying to do is, if there's reasonable suspicion and the cop's having an engagement, having a conversation, they ought to be able to videotape that. But when there's no reasonable suspicion and the person doesn't understand what they're willingly participating in, there's a material difference in that willing participation.
Mr. Porter, do you want to speak to that, or any representative of your group?
Yes, sir. With due respect to Chairman Setzler, and we agree on many things, but the purpose of this bill, and I have to go back somewhat historically, is that 1611-64 was originally written to protect people from hidden cameras in tanning beds and changing rooms, and it changed Georgia law from what was called a single party consent. In other words, if one party to a conversation agreed to the recording of that conversation, then it could be recorded, and there was no distinction between audio and video. Because of the video cameras, this legislature created a distinction between audio and video and required that there either be consent, or that it set out certain exceptions to recording videos in a private place, which a home would fall into that category. Given the events in Ferguson and given the events across the country, there has been a growing sense that body cams on police officers are good things, that they serve a societal interest. However, in order for them to serve that societal interest, they have to be recording, and implicit in a consent analysis is the ability to deny that consent. So that if the officer were called to a domestic situation and was going into the house, he might not have reasonable suspicion, he might not have articulable suspicion, he may merely be investigating. That would be the circumstance where maybe we might most want the recording of events that may take place that could end up in a use of deadly force situation. Under the amendment, those would be excluded. So I guess what we really need to think about, along the lines of what Chairman Pack said, is what we tried to create in this was an opportunity for body cams to be authorized under Georgia law, whereas right now we believe they're not. Then I guess you'll have to decide, and we recommend that if you're going to have body cams, you do it by creating the law enforcement exception that as long as that officer is in the lawful discharge of his duties, he's authorized to record activities that occur within the range of the camera. And I think that's the best option. So, because as soon as you give the people who are being videoed any say in it, if they say no, the officer has to shut it off, and you've lost the value of the video cam.
And then if an unforeseeable exigent circumstance arises and the officer has to react and something's going down and they got nothing on videotape.
And he may not have time or the ability to turn the camera back on.
There's not going to be that time if that situation
That would
occurs.
be my suggestion.
Let me recognize Ms. Ballinger, then I'll go back to Mr. Setzler.
Well, my question was just the logistics of that, as far as to the author of the amendment. Like you approach a group of four. We'll just say two say yay, two say no. How would that work?
Under current Georgia law, the no's would win. The officer would not be able to consent or record. If the four people are of equal authority over the premises, then the no's win under Georgia
Mr. Chair,
Okay.
this doesn't apply walking around on a street. If you're walking on a street, you're in the open. There's no expectation of privacy. So video camera can roll anytime, and if you're on a street corner talking to a police officer, someone can drive by, a private party can drive by in a car and videotape the whole thing. This really meaningfully applies when officers are stepping into places where there is an expectation of privacy. If an officer says, "Hey, I'm here to check on something. Can I come in?" You say, "Sure." There's a material difference when you're stepping into a place now where there's typically an expectation of privacy. It's not the side of the street. It's not an officer in a crowd talking to someone in public. You really are stepping into a private place, and individuals ought to know what they're consenting to. I mean, there's a whole array of settings. We could use an extreme example. People that consent to sexual contact with somebody, they might consent to sexual contact, but they're certainly not going to consent to videotaping of said contact. And that's a materially different thing when you're in a personal setting. And you think of that as kind of the most extreme circumstance. Wait a minute, I consented to certain act with you as consenting adults, but I certainly didn't know you were going to be running a videotape. Likewise, stepping down towards a more routine, day-to-day circumstance.
Mr. Chairman, if I could interject, it does specify lawful performance of his or her official duties. So I would hope they wouldn't be in their official performance of their duties.
No.
Well, let's let Mr. Setzler finish.
And again,
his point.
I mean, by way of analogy, there is a material difference in consenting to an activity with somebody than consenting to a videotaped activity with somebody. That's the fundamental premise of this. Inviting an officer to walk into my house and inviting an officer to walk into my house and videotape things is a materially different thing.
There's nothing in the amendment that goes to what you referred to as a personal space, personal area of the home.
But Mr. Chairman, if you're
Unless I'm missing it,
if you're in a public place, there's no requirement for this. The statute only that doesn't kick in if you're walking around a public place. That's lawfully obtainable evidence today. This deals with, if you walk back to the top of the code section, the whole code section deals with peeping Tom issues, invasion of privacy. That's the section of the code you're dealing with. So you're talking about being in private places.
Would it satisfy you? Because I think the person could kick the officer out. There's no basis for them to be there. You could say you could leave my house. That's, would you be satisfied if there was some, without the withdrawing the consenting recording, but maybe just a notification that when you enter somebody's house that I want to let you know that we're recording? Or is that something you think that will cut against?
I think what you're going to find is an extraordinary number of people will say you're not going to record what goes on.
Or not, don't come into the house, right?
Whatever value this body places on body cams will be lost by someone who is subject to the lawful contact of the police officer having the right to say you can't record me.
And Mr. Chairman, I would agree with Mr. Porter. I would agree. I mean, there is a material difference with an officer walking into a house videotape. I do think it's going to impact the people the circumstances in which folks will invite someone into their home. I mean, I agree with him completely. I do think there's a material difference there.
Mr. Grabley.
Thank you, Mr. Chairman. I'm trying to kind of visualize the context. So, and correct me if I'm wrong. We're in my subdivision. A fight breaks out between some neighbors across the street in the yard. Law enforcement's called. Maybe the officer goes to several other neighbors' house, says, "Hey, I understand you were home. I'd like to talk to you about the incident. Maybe you saw these two neighbors fighting. You mind if I come in and ask you some questions?"
Yes, sir.
So in that context, as the homeowner, if the officer's asking me the questions, and I can invite him into my house, would the context be, "I don't mind if you come in at all, officer. I was here. I did look out the window and see what was going on, but I'd prefer you not to record coming into my home." That's what we're discussing. I mean, I'm just trying to get a visualize.
The amendment would be the officer would have to say, I'm operating a video recorder. Will you allow me to record our conversation? Will you allow me to video record our conversation while I'm in your house?
So the amendment would go to whether or not I could say yay or nay.
That's as I
give me the right to say yay or nay in my home.
The officer was operating pursuant to reasonable suspicion. then he wouldn't have to let them know that. But if he's operating pursuant to, hey, Miss Jones, can I come in and sit down and kind of talk about what you saw? Miss Jones is potentially a suspect. She doesn't. Who knows what's going to come out of that conversation? Miss Jones says, "Come on in, officer. I'm fine to have you come in the house." It's
No.
to this reporter, but it's a material difference when she knows she's being through that conversation about walking through a living room.
Furthermore, Mr. Chairman.
Sure.
So the suspicion would then be if the officer has some knowledge from another neighbor. Mr. Gravely, I understand you were the one that threw the beer bottle across the street and instigated the fight. I'd like to come in and talk with you. At that point, he's speaking to me in a different capacity. You were involved. I understand you might have been involved in this altercation.
Or three adults in the front yard saw that. That probably raises a reasonable suspicion. I don't know that one person do obliquely, but when you meet that standard, then the cops, he's in a place where he has reasonable suspicion. He's coming to talk to you. If he does, you're not inviting him to that.
Which in my mind would be different if you live in the subdivision. I understand you might have been home. I understand you weren't involved, but I just want to ask if you saw anything. Maybe I want to take some notes and see what you may have saw or seen. Okay.
Without getting too far into the hypotheticals, though, Mr. Gravely, is I think the thing that we're trying to deal with in the body cam situation is you invite that officer into your home and then you pull a gun and he has to kill you.
Because I'm inviting him in his official duties. In that capacity, I'm inviting you in.
You're inviting him in, and then you pull a gun, and for some reason he has to kill you. Do you want that on videotape for a determination of whether there was a lawful use of force, or because the privacy aspect has been waived? Any privacy aspect you have in your home is waived when you invite that officer in, because he can testify to what he saw with his eyes. The recording, it really goes to the weight and credit of it. It doesn't go to the admissibility of it. The officer could testify. I walked into Mr. Gravely's house and I saw a seal of Georgia and a signed copy of the roster of the House of Representatives. The video would not really make any difference in terms of the invasion of the privacy. The officer's in there.
Well, again, we talk about weight and credit. If it's significant, it really works on both sides. And if it's significant to record it for admissibility and use in court because it has weight and credit, then one is, on the flip side, one is that there is a material difference, both for prosecution or on the defense side. And that's really the purpose of the amendment, is that there's a recognition that video recording of something is good. And when people believe they're operating pursuant to consent. Hey, sure, come on in. We're glad to have you. Oh, I'm being video recorded. Okay, I'm cool with that. Come on. But you understand you're on your P's and Q's. There's a material difference in the conversation as opposed to just chatting with police officers. Because we're talking about a private place. We're not talking about this.
All right. I think we've come to a place where
I think
people are where they are.
You have to make a decision.
Yeah,
Yes.
I think people are where they are. 2, 3, 4, 5, 6. Once Ms. Ballinger steps back into the room, we'll go ahead and act on the amendment to the amendment. Thank you. All right, the question will occur on the amendment to the amendment offered by Mr. Setzler. I assume all members have a copy of it at their desks. All in favor of the gentleman's amendment signify by raising your hand. Opposed? The chair votes aye. The chair votes no. Excuse me. The amendment is not adopted. The question then goes on the underlying amendment on House Bill 430 as an amendment to SB 94. All in favor of the amendment signify by saying aye. Opposed? The ayes have it, and the amendment is adopted. On the underlying motion of due pass, and this will be by substitute, that amends HB 430 to SB 94 with passage by substitute. All in favor of the gentlelady's motion signify by saying aye. Opposed? The ayes have it, and the motion is adopted. The ayes have it in the opinion of the chair. Is there an ask for a hand vote? Hearing none, the opinion of the chair, the ayes have it, and the motion is adopted on due pass by substitute of SB 94, which incorporates HB 430. Thank you, members of the committee, for your time and for your attention, and we are adjourned.